this is just kind of blowing my mind here, right? There's a damage disclaimer in a 1.8 million euro contract. What? Hey everybody, how you doing? It's Leonard French, your favorite copyright attorney. And I know there's about a whole bunch of you out there that just been waiting for this response. And so when I heard that it had dropped, I took a look at it, and it was definitely something that's presentable. Doesn't need a whole lot of serious explanation. They've done a pretty good job with it. So let's jump right in. So Crytek sued Cloud Imperium and Robert Space Industries over their change in using the Crytek engine to using Amazon's Lumberjack, which uses the Crytek engine, but is also something made by Amazon. And this happens to have all the information that I think we need to see what's going on. This action should never have been filed. The first amended complaint, yes, it's true, Crytek filed an amended complaint. We're going to get to that because that comes up better in a moment. The first amended complaint, like the initial complaint before it, sacrifices legal sufficiency for loud publicity. Though Crytek GmbH, which is like an LLC or something here, it's a German corporation, twice now conceals the actual game license agreement from the court and the press. The court possesses the power to examine the incorporated GLA on this motion. And they've provided the GLA, so we can go through the GLA too. The GLA eliminates virtually every claim and remedy Crytek seeks. Crytek's admission that defendants are not even using Crytek software gets rid of the rest. The allegations regarding defendants' co-founder Ortwin Freiermuth and another employee Carl Jones, the quote-unquote offending allegations, though modified in retreat by Crytek's counsel after being confronted with a Rule 11 motion based on a false allegation contained in the initial complaint, still bear absolutely no material relation to any claim or named party, and have everything to do with generating misleading, scandalous press. Neither of Crytek's two contrived claims can survive the contract, and all its remedies are contractually barred, justifying dismissal as a matter of law. The court also should send a message to Crytek by striking the immaterial, impertinent, and scandalous offending paragraphs in paragraph 15 of the first amended complaint. Well, let's take a look. I happen to have the First Amendment complaint here. This is the original complaint. Here's the First Amended complaint. So here's paragraph 15. The GLA was extensively negotiated. Negotiations on behalf of the defendant were led by Freiermuth, one of defendant's co-founders. In prior years, Freiermuth also represented Crytek in negotiations of similar license agreements with third parties. Notwithstanding that he had confidential information about Crytek's licensing practices that would unfairly advantage defendants, Freiermuth never recused himself from those negotiations and never resolved that conflict of interest with Crytek. That sounds pretty scandalous. So then we go over to the First Amended complaint. Paragraph 15 is much shorter. Now, this First Amended complaint was just filed on the 2nd of January. Why would it be much shorter? It says the negotiations were extensively negotiated on behalf of the defendants. The negotiations were led by defendants' co-founders Freiermuth. In prior years, Freiermuth had represented Crytek in negotiations of similar license agreements with third parties and had confidential information about Crytek's licensing practices. But it completely omits the part about having not vetted a conflict of interest, which is a rather scandalous thing because lawyers have a preemptive, an affirmative duty. We have to check ahead of time for conflicts of interest between clients, and we can only represent clients who have no concurrent conflict of interest or who have approved a concurrent representation and they have some kind of concurrent conflict of interest that's not directly adverse in like the same case or something like that. It gets complicated, and we have to do this kind of conflict check all the time, and we're used to doing it. So to accuse an attorney of not doing their conflicts check, or worse, getting the conflicts check wrong, is a serious freaking accusation. So note that that is gone. So, summary of arguments. This is back to the motion to dismiss. Crytek's claims for breach of contract and copyright infringement against defendants are all tied to alleged violations of the GLA that Crytek deliberately omitted from its initial complaint, quote, the initial complaint, and now omits from the first amended complaint, the FAC. Crytek hides the GLA because its express language precludes Crytek's claims and remedies as a matter of law. So we have the GLA. We're going to take a look at the GLA in a little bit here. They do a really good job of citing it in this memo, so I don't know that we need to go over the GLA line by line in a long video. The GLA granted CIG a license to use Crytek's video game engine, CryEngine, in a video game called Star Citizen and a related video game called Squadron 42. Crytek pleads that CIG's alleged previous use of the engine in Squadron 42 exceeds the scope of the GLA. The omitted GLA reveals that the defined term game, where CIG can use the engine, includes both the game currently entitled Space Citizen and its related space fighter game Squadron 42. And then there's a footnote here, and the footnote is that the recital in the GLA erroneously refers to Space Citizen when it should be Star Citizen. I don't know what effect that has. I'm assuming that's just a mistake. If that's more than a mistake, then we're going to have to hear about that from Crytek. And, okay, so maybe it is a good time to go over to the license agreement. Let me scroll all the way down here. This is the game license agreement, November 20th, 2012, between Crytek and Cloud Imperium Games. Note that Robert Space Industries is not on this agreement. And it says right here, licensee desires to use, and Crytek desires to grant a license to use, the CryEngine for the game currently entitled Space Citizen and its related space fighter game, Squadron 42. And its related space fighter game, Squadron 42. That seems pretty clear to me. Let's continue. Back to the motion to dismiss. Moreover, a December 23, 2016 press release that Crytek references, quotes from, and relies upon to support its claims, but also conceals from the court, reveals that CIG is no longer using the engine in Squadron 42 at all, thus rendering Crytek's related claims for breach of the GLA and copyright infringement subject to immediate dismissal. The GLA further shows that CIG has an exclusive right, not a duty, to use the engine in the game. Through hiding the GLA, Crytek contorts the word exclusively to argue that the word means that CIG somehow is required to use the engine in the game. The plain language of the GLA, where the grant of rights to CIG appears, plus the well-established concept of an exclusive license, instead establish that the word exclusively simply means that CIG's right to use the engine in the game is exclusive to CIG, and Crytek may not give that right to anyone else. Crytek's tortured interpretation of the GLA would turn the GLA and well-established Ninth Circuit law about exclusivity on its head. CIG's obligation to include copyright and trademark notices for Crytek necessarily applies only when CIG actually uses the engine, which Crytek pleads CIG is not. Crytek's claim for damages, an essential element of any breach of contract claim, is precluded by express language in the GLA barring either party from seeking any damage from the other. The FAC also seeks various forms of monetary damage and equitable relief that are unavailable under the GLA or as a matter of law, including statutory damages and attorney's fees under the Copyright Act, punitive damages, and an injunction. The GLA shows on its face that defendant RSI is not even a party to the GLA and has no business being named at all. For all these reasons described in more detail below, the FAC should be dismissed in its entirety and with prejudice. With prejudice means that it cannot be brought again. The claims are extinguished. They have been adjudicated. Finally, in the event the court declines to dismiss the first amended complaint, the court should at least strike the offending allegations on the ground that they are immaterial, impertinent, and scandalous, which is the standard for a strike. Statement of relevant allegations. CIG, together with its affiliate RSI, is a video game company that since 2012 has been developing a new game called Star Citizen, not Space Citizen, described as an epic space adventure, trading, and dogfighting video game. On November 20th, 2012, CIG entered into the game license agreement with Crytek, another video game company that owns rights to a game engine called CryEngine. Pursuant to the GLA, CIG agreed to pay Crytek a buyout license fee for access to and use of the engine in the game defined in the GLA as the game Star Citizen and its related space fighter game Squadron 42. The GLA grants certain exclusive rights in favor of CIG, including the exclusive right to embed the engine in the game and the exclusive right to exploit the game. No provision in the GLA states that CIG shall not embed any other engine or third-party software in the game. On December 23, 2016, CIG announced that it stopped using the engine in both Star Citizen and Squadron 42, and now was using the Amazon Lumberyard engine. Both Star Citizen and Squadron 42 remain in development. Crytek claims it is damaged because CIG is not using the engine. Crytek filed its initial complaint against CIG this year, December 12th, or rather last year, wow. Crytek filed its first amended complaint on January 2nd, after defendants' counsel notified Crytek's counsel pursuant to local Rule 7-3 that defendants were planning to file a motion to dismiss and strike, and serve a motion pursuant to Rule 11 based on Crytek's improper inclusion of and refusal to withdraw a false statement in the initial complaint that Ortwin Freiermuth, an attorney who co-founded CIG and RSI, had negotiated the GLA on behalf of defendants and against Crytek without resolving a conflict of interest. Contrary to the false statement contained in paragraph 15, Mr. Freiermuth's law firm had obtained written conflict waiver signed by Crytek prior to negotiating the GLA on behalf of CIG. Although the first amended complaint addressed a few of the deficiencies defendant had raised regarding the initial complaint, the first amended complaint retains several fundamental defects. Moreover, while Crytek withdrew the false statement regarding Mr. Freiermuth, the First Amendment complaint retains certain immaterial, impertinent, scandalous statements regarding him, as well as Carl Jones, another employee of CIG. Rule 12b-6 of the Federal Rules of Civil Procedure permits a party to move to dismiss a complaint on the ground that it fails to state a claim upon which relief can be granted. To survive a motion to dismiss under Bell Atlantic v. Twombly and Ashcroft v. Iqbal, those are very important cases, a complaint must contain sufficient factual matter accepted as true to state a claim to relief that is plausible on its face. The court need not accept as true threadbare recitals of legal elements of a cause of action supported by mere conclusions and conclusory statements. This court is empowered to consider the omitted GLA as well as the omitted 2016 press release under the doctrine of incorporation by reference, even though plaintiff chose not to attach those documents to the first amended complaint. The Ninth Circuit has extended the doctrine of incorporation by reference to consider documents in situations where the complaint necessarily relies upon a document or the contents of a document are alleged in a complaint. The document's authenticity is not in question, and there are no disputed issues as to the document's relevance. Otherwise, a plaintiff within a legally deficient claim could survive a motion to dismiss simply by failing to attach a dispositive document on which it relied. The First Amended complaint fails to state a claim for breach of contract. To state a claim for breach of contract against CIG, Crytek must allege the following elements: existence of a contract, performance by the plaintiff or excuse for non-performance, breach by the defendant, and damages. As shown below, Crytek fails to state a claim for breach of the GLA because RSI is not a party to the GLA, because the GLA expressly allows activities that Crytek contends constitute breaches, and the GLA expressly precludes Crytek's claim for damages. First, RSI is not a party to the GLA. Under California law, a plaintiff cannot maintain a breach of contract claim against an entity who is not party to the contract. Here, though the first amended complaint alleges that defendants entered into the GLA with Crytek, in fact, the sole parties to enter into the GLA were Crytek and CIG. Crytek does not and cannot allege that RSI is a party to the GLA. And we did see that. I'm not going to cover that right now, but yes, that we saw that it was only between those two. Crytek's initial complaint contained no allegations whatsoever regarding RSI, nor did it explain why RSI is included as a defendant to the breach of contract or copyright infringement claims. In an attempt to remedy that deficiency, Crytek added a single sentence to the first amended complaint, quote, "By their actions and conduct, defendants established that RSI was bound by the GLA as if it were a signatory thereto," end quote. This threadbare allegation, which fails to identify any actions or conduct by RSI that would bind it to a contract between two other parties, is entirely conclusory and provides no basis for naming RSI as a defendant to either claim in this action. Accordingly, the claims against RSI should be dismissed. Okay, that one's pretty simple. RSI isn't a party to this contract, and therefore how can it breach the agreement? That's a pretty simple one to me. And I would really need to hear from Crytek how they intend to connect RSI to that, to anything at all. If there's no legal relationship between them, then those two shouldn't be involved, and all damages or lawsuits or claims or action should be between Crytek and Crytek and CIG. The GLA expressly allows activities that Crytek contends constitute breaches of the GLA. CIG has an exclusive right, not an obligation, to embed the engine in the game. Crytek's claim that CIG was forced to use the engine in the game is based entirely on isolating the word exclusively, contained in Section 212 of the GLA, from the language of that provision and everything else in the GLA. However, the express language of the GLA and the concept of exclusivity under well-established copyright law show that the exclusivity restriction is on Crytek, not on CIG. In interpreting the GLA, quote, "The whole of a contract is to be taken together so as to give effect to every part, if reasonably practicable, each clause helping to interpret the other. The contract must be construed as a whole, and the intention of the parties must be ascertained from the consideration of the entire contract, not one isolated portion. Applying this rule of construction, it is clear that the term exclusively was included in Section 212 of the GLA to protect CIG's license, not restrict it. The title of the document itself, Game License Agreement, supports this conclusion. Merriam-Webster defines the word as permission to act or freedom to act. The words of a contract are to be understood in their ordinary and popular sense, rather than according to their strict legal meaning, unless used by the parties in a technical sense, or unless a special meaning is given to them by the usage, in which case the latter must be followed. Consistent with the ordinary meaning of the term license, the recitals of the GLA state that CIG desires to use, and Crytek desires to grant, the license to use the Crytek engine for the game. Following certain definitions in Section 1, Section 2, then, defines the grant of license from Crytek to CIG. Within Section 2, Section 2.1, defines the grant, which, followed by Section 2.2, sets forth certain restrictions on use. The term exclusively, which provides the sole basis for Crytek's claim, is found in the grant section, not in the restrictions section. No provision in the GLA states that CIG shall not embed any other engine or third-party software in the game. 2.1 provides, in relevant part, grant, subject to strict and continuous compliance with the restrictions in this agreement and timely payout, Crytek grants to licensee a worldwide license only to non-exclusively develop, support, maintain, extend, enhance CryEngine, such right being exclusive only with respect to the game, and non-sub-licensable except as set forth in Section 2.6. To exclusively embed CryEngine in the game and develop the game, which right shall be sub-licensable pursuant to 2.6. To exclusively manufacture, market, promote, license, sell, publish, and exploit the game in any way, which right shall be freely sub-licensable. This language, plus the rest of the hidden document, reflect the unremarkable and obvious truth. There are some rights granted to SIG that may be granted to others by Crytek, non-exclusive, but others where Crytek is prohibited from granting such rights to others, exclusive. Obviously, SIG would never have a document that even remotely suggests Crytek should grant somebody else the right to embed the engine in the game. Crytek's House of Cards pleading tries to restrict rather than protect SIG's granted rights. Ninth Circuit copyright jurisprudence regarding exclusivity accords with the GLA, underscoring the absurdity of Crytek's attempt. The Ninth Circuit recognizes that the essence of an exclusive license under the Copyright Act is that the copyright holder permits the licensee to use the protected materials for a specific use and further promises that the same permission will not be given to others. Contrary to Crytek's sham interpretation and consistent with well-established jurisprudence on exclusive licenses, the GLA uses the word exclusively to signify Crytek's promise not to permit anyone other than SIG to embed CryEngine in their game and develop the game. The GLA's use of the terms exclusively and non-exclusively in Section 2.1 buttresses this conclusion. Specifically, the GLA makes clear that any rights in the engine as they relate to the game are exclusive to SIG, the developer of the game. Thus, Crytek grants SIG the exclusive right, meaning SIG and no one else has the right to develop, support, maintain, extend, or enhance the CryEngine with respect to the game, embed CryEngine in the game and develop the game, manufacture, market, and promote, sell, license, publish, and exploit the game in any way. On the other hand, the non-exclusive grant of rights in Section 2.1.1 allows Crytek to permit others to develop, support, maintain, extend, or enhance CryEngine, provided such activities are not with respect to the game. Accordingly, Crytek's claims that the GLA forces SIG to use the engine and that SIG breached the GLA by using a different game engine are meritless. This flaw, combined with the plain admission that SIG has elected to move to a different engine, unravels much of the FAC. Wow, that's a lot. That's pretty big. So it sounds to me like what we were looking at was a standard game license where Crytek would have the right to continue to develop the game engine, but not the right to prevent anyone from developing their game with the game engine. In other words, Crytek isn't claiming any rights in the game, and the game developers aren't claiming any rights in CryEngine. That sounds like a really normal game development license term to me. Let's continue. Crytek alleges that SIG breached the GLA by failing to include copyright and trademark notices. SIG's obligation to include the copyright and trademark notices necessarily requires SIG's actual use of the engine in the game. While the GLA includes a provision requiring SIG to include copyright and trademark notices for Crytek, that requirement is subject to an implied condition that SIG actually uses the engine. Stipulations which are necessary to make a contract reasonable are implied in respect to matters concerning, and the contract manifests no contrary intention. So again, in totality, you take everything together. Otherwise, the notices would misrepresent reality and could mislead that SIG is using Crytek's engine when it is not, precisely as Crytek admits. SIG's planned release of Squadron 42 does not breach the GLA. Crytek contends that SIG breached the GLA by using the engine to develop Squadron 42. Crytek tries to hide the critical fact readily apparent on the face of the GLA that the GLA expressly defines the game to include both Star Citizen and Squadron 42. Whereas licensee decides to use and Crytek desires to use and desires to grant a license to use the CryEngine for the game, currently entitled Space Citizen, and its related space fighter game Squadron 42 together hereafter the game, etc. CIG's right to use the engine in connection with the development of Squadron 42 is further established by Exhibit 2 of the GLA, which contains a more detailed description of the game. That exhibit itemizes Squadron 42 as the first feature of the game, a single-player offline or online drop-in, drop-out co-op play experience versus Star Citizen, the persistent universe hosted by CIG. Thus, contrary to Crytek's claim that CIG's alleged prior use of the engine to develop Squadron 42 was a breach of the GLA, such use was expressly authorized by the GLA. Furthermore, Crytek's claim that CIG is in breach of the GLA by planning to release Squadron 42 as a standalone game fails for the simple reason that CIG is no longer using the engine in Squadron 42. Crytek attempts to hide this fact from the court by misrepresenting the context of the press release. To support its meritless claim that CIG broke a non-existent obligation to use the engine in the game, Crytek alleges that defendants announced that they were using Amazon Lumberyard video game engine for Star Citizen. This is a blatant misrepresentation of CIG's announcement. In fact, CIG announced in the 2016 press release that it had switched to Amazon Lumberyard for both Star Citizen and Squadron 42. Thus, Crytek's claim that CIG is breaching the GLA by using the engine in Squadron 42 is flatly contradicted by the press release, which makes crystal clear that CIG is using Lumberyard, not the engine, in Squadron 42. Furthermore, the GLA expressly precludes the alleged contract claims for damages. An essential element for a claim for breach of contract are damages resulting from the breach. A breach of contract without damage is not actionable. Here, the GLA expressly precludes Crytek from seeking any damages whatsoever, Section 614, except for intentional acts or omissions or gross negligent acts. In no event shall either party hereto be liable for any damages, including but not limited to indirect, incidental, special, consequential, damages for loss of profits, revenue, data, or use incurred by either party or any third party, whether in an action or in contract or in tort, including negligence or otherwise, even if the relevant party has been advised. This unambiguous language controls. When a contract is reduced to writing, the intention of the parties is to be ascertained from the writing alone if possible. After defendants' counsel pointed out this fundamental problem with Crytek's claim for breach of contract, it was pleaded in the initial complaint. Crytek attempted to fix the issue by inserting the word intentionally before the words breached the GLA in paragraphs 56 to 59. Defendants intentionally breached the GLA, further intentionally breached the GLA. Presumably, Crytek inserts the word intentionally in order to argue that its claim for damages against defendants falls within the exception for intentional acts or omissions. Crytek's meager attempt to circumvent the GLA's clear protection against either party seeking damages from the other should be rejected. Based on well-established principles distinguishing between contract and tort, it is clear that the exception for intentional acts or omissions applies solely to claims sounding in tort, not contract. Contract and tort are different branches of law. Contract law exists to enforce legally binding agreements between parties. Tort law is designed to vindicate social policy. In contrast to tort law and traditional contract law, the motive of the breaching party generally has no bearing on the scope of the damages that the injured party may recover for the breach. The remedies are limited to contract damages. Motive is irrelevant to breach of contract because the intentional breach of contract has come to be viewed as a morally neutral act, as exemplified in Justice Holmes' remark that the duty to keep a contract at common law means a prediction that you must pay damages if you do not keep it, and nothing else. The California Supreme Court has held that outside the insurance context, a claim for an intentional or tortious breach of contract may lie only when the breach is accompanied by a tort, such as fraud or conversion. The means used to breach the contract are tortious, involving deceit or coercion. One party intentionally breaches the contract, intending or knowing that such a breach will cause severe, unmitigatable harm in the form of mental anguish, personal hardship, or substantial consequential damages. Here, although Crytek claims that defendant intentionally breached the GLA in various ways, neither that conclusory allegation nor any other facts alleged in the First Amendment complaint are sufficient to bring Crytek's ordinary claim for breach of contract within any of these narrow exceptions. Accordingly, based on the plain language of the GLA, Crytek cannot plead any damages referenced vaguely but repeatedly throughout its claim for breach of contract, and the claim must be dismissed with prejudice. The complaint fails to state a claim for copyright infringement because the GLA expressly authorized defendants' prior use of the engine in Squadron 42, and defendants are now not using the engine in Squadron 42. The sole basis for Crytek's claim of copyright infringement is the allegation that defendants are exceeding the scope of the GLA by using the engine to develop Squadron 42, a game Crytek pleads is separate from Star Citizen. However, Crytek's claim for copyright infringement fails because CIG's prior use of the engine to develop Squadron 42 was expressly authorized by the game license agreement. Moreover, to recover for copyright infringement based on breach of a license agreement, the copying must exceed the scope of the defendant's license, and the copyright owner's complaint must be grounded in an exclusive right of copyright. Crytek cannot maintain its copyright claim for the simple reason that Crytek pleads that defendants are not using any copyrighted work belonging to Crytek to develop either Star Citizen or Squadron 42. Even if there were any merit to Crytek's claim that the GLA requires CIG to use the engine in the game, there is not. Crytek cannot possibly establish a claim for copyright infringement based on defendant's decision not to use the engine in Squadron 42. The court should dismiss Crytek's improper claims for damages and injunctive relief that are unavailable as a matter of law and under the express terms of the GLA. Even if the court does not dismiss the breach of contract or copyright infringement claims in their entireties, the court should dismiss Crytek's improper claims for damages and injunctive relief that are unavailable as a matter of law and under the express terms of the GLA. Monetary damages. Crytek's claim for monetary damages against CIG based upon CIG's alleged breach of the GLA should be dismissed in light of Section 614, which, as discussed, precludes either party from being liable for damages. Injunctive relief. In its prayer for relief, Crytek requests the court enter a permanent injunction. Crytek's claim for injunctive relief should be dismissed. First, the claim for injunctive relief should be dismissed insofar as it conflicts with Section 10.7 of the GLA, which expressly provides that under no circumstances shall Crytek be entitled to enjoin the publishing or other exploitation of the game. Second, the First Amendment complaint states no facts to support a claim for injunctive relief. In order for the court to grant injunctive relief, Crytek must plead facts that, if proven, would establish that it suffered irreparable injury, that the remedies at law are inadequate, the balance of hardships favor plaintiff, and injunction will advance the public interest. As the FAC states no facts to support any of these elements, Crytek's claim for injunctive relief must be dismissed. Crytek's claim for statutory damages and attorney's fees under the Copyright Act must be dismissed, which provides that no award of statutory damages or attorney's fees shall be made for any infringements for copyright commenced after the first publication of the work and before the effective date of its registration. Here the FAC alleges that the infringement commenced in 2015 or 16. Crytek's copyright registration is dated December 11th, 2017, and states that the engine was first published in February 23rd, 2012. Accordingly, Crytek's claims for statutory damages and attorney's fees are barred as a matter of law. Okay, that's interesting. They skipped something here. They said that copyright can't be used for this because they didn't register it properly, and that copyright statutory damages and attorney's fees can't be claimed because of the publication dates. But you also can't use copyright as a claim when there's a breach of contract. I get this question a lot, actually. someone has a contract with someone, and then someone breaches that contract by committing some kind of illegal copying. Well, that's a breach of the contract, and contract damages apply, not copyright damages. So you can't go after those huge statutory damages under copyright law if you have a breach of contract. So they left that out of this, or maybe they put it someplace else and I just forgot that I read it or something. Punitive damages. Finally, Crytek's claim in its prayer for relief seeking punitive damages in an amount to be determined at trial should be dismissed because punitive damages are not recoverable for breach of contract or for copyright infringement, which is true. The court should strike immaterial, impertinent, scandalous allegations. In a ham-fisted attempt to smear one of the defendants, as well as Carl Jones, a current employee, the FAC includes the following assertion. Defendants entered into the game license agreement that was extensively negotiated. Freiermuth had represented Crytek in similar negotiations and had access to confidential information. Carl Jones was there or something and later left Crytek to become an employee of defendants. The court should strike the offending allegations on the grounds that they are immaterial, impertinent, or scandalous. Immaterial because they have no essential or important relationship to Crytek's claim for breach of or infringement of the engine. Similarly, the statements are impertinent because they do not pertain to any of the issues raised by Crytek's claims for breach of contract or copyright infringement. Finally, the statements are scandalous because they cast a cruelly derogatory light on Mr. Freiermuth and Mr. Jones without any justification. The scandalous nature of the offending allegations must also be viewed in light of the initial complaint. As discussed above, paragraph 15 of the initial complaint included the allegation that Mr. Freiermuth had negotiated the GLA without resolving a conflict of interest between the parties, his conflict of interest between the parties, an allegation that was demonstrably false, given that Mr. Freiermuth had obtained a written conflict waiver from Crytek prior to negotiating the GLA on behalf of CIG. While the damage to Mr. Freiermuth caused by Crytek's irresponsible inclusion of the false allegation cannot be undone, and the gratuitous misleading comments about Mr. Freiermuth and Jones and the FAC have already been published, the court should send a message by ordering that the immaterial, scandalous, pertinent, etc. material be stricken. For the reasons stated above, the court should dismiss Crytek's irresponsible FAC in its entirety with prejudice, or in the event anything remains or leave to amend is granted, order Crytek to strike the identified portion of paragraph 15 of the FAC. Wow. So that's a lot different than what we read back in December, isn't it? It really sounded like Crytek had some kind of exclusivity agreement that Star Citizen would be developed with CryEngine and published with CryEngine, and that Crytek was very upset that they weren't going to get their publicity or their money or something. It sounds more like this was a standard game development license agreement between a game engine company and a game developer. It sounds like there was the exclusivity between them really was so that Crytek could continue to develop CryEngine without worrying about Star Citizen or RSI or CIG infringing upon their rights, and RSI could continue to develop Star Citizen without infringing upon the CryEngine. So that sounds pretty standard to me. Obviously, each developer is going to continue to want to make their product, and as they do so, they're going to want to define whose rights belong to who. So that sounds totally normal to me. And assuming that Crytek doesn't have some really good argument in the other direction, this sounds like a knockout punch to me. I don't really see how Crytek is going to recover this lawsuit from this unless some of this stuff is just flat out lies or something. Well, we don't necessarily have to take just the attorney's word for it. How about that? I'll put it that way. We can go over here to this. The declaration of Jeremy Goldman in support of Defendants Motion to dismiss. I, Jeremy Goldman, make this declaration on the basis of personal knowledge, over 18, attorney licensed to practice law. Attached hereto is Exhibit A, a true and correct copy of the game license agreement. Exhibit B is a true and correct copy of the amended game license agreement on September 12, 2014. Exhibit C is a true and correct copy of the press release December 23rd, 2016. Among other deficiencies in the initial complaint, paragraph 15 of the initial complaint included the false and improper allegation that Ortwin Freiermuth, an attorney who co-founded CIG and RSI, had negotiated the GLA on behalf of defendants and against Crytek without resolving a conflict of interest. Upon learning of the filing of the initial complaint, our law firm notified Crytek's counsel of the falsity of the offending allegation. We pointed out that, contrary to the statement contained in the offending allegation, Mr. Freiermuth's law firm had obtained a written conflict waiver. Crytek initially refused to withdraw the offending allegation. On December 28th, I participated in a teleconference with Crytek's counsel pursuant to Local Rule 7.3 and discussed our anticipated motion to dismiss. During the call, I also communicated defendant's intent to serve upon Crytek's counsel a motion pursuant to Rule 11 based on Crytek's improper inclusion of the offending allegation. On January 2nd, Crytek filed its first amended complaint. So, let's take a look. Fully executed game license agreement. So here's the whereas paragraph, Space Citizen and Squadron 42. And you have to take the whole thing into account, remember? So you have to read the whole license and see what it says. Here's the paragraph 2, the section 2. Crytek grants licensee, worldwide license only, to non-exclusively develop the CryEngine. So that means that licensee can make developments and changes, enhancements to CryEngine, but it's not exclusive to defendant or licensee. To exclusively embed CryEngine in the game, so that's a license that's exclusive to licensee. So only licensee has the right to embed CryEngine in Star Citizen and Squadron 42. And to exclusively manufacture, promote, sell, etc. the game. So they're saying that those exclusivelys mean that RSI has, or SIG has the exclusive right, not Crytek. And then here's that restrictions on use. If there were restrictions on use, they should say in here, licensee shall not publish or distribute CryEngine, use CryEngine in any way which discloses source code, use, copy, reproduce part of CryEngine or documentation, reverse engineer or decompile CryEngine, copy, sublicense, sublease, or otherwise distribute Crytek's games, including Crysis. So those restrictions seem pretty normal and do not seem to include any restriction on exclusivity of using CryEngine in Star Citizen. It sounds like there was no obligation to use CryEngine in Star Citizen. There's some other stuff in here, but what I wanted to get to were some of these payments, because there are some rather interesting payments in here. License and buyout fee for PC Mobile Next Gen. Licensee shall pay to Crytek a fee for PC, Windows, Mac OS, mobile platforms, Next Gen amounting to 1,850,000 euros, including a license fee amounting to 600,000 euros for a royalty buyout amounting to 1.25 million euros, 250,000 euros on or before December 30th, 2012, 700,000 upon delivery of the agreement, 400,000 upon first public release, 250,000 before July 15th, or July 1st, 2015, 250,000 before July 2016, 150,000 for distributing mod tools, 100,000 for a support extension. No royalties other than that. So that's what they were paying for Crytek. $1.8 million, it looks like. In euros. I don't even know what a euro is. I'm an American. I went to an American high school. And then here's the various warranties here. Let's see. Except for intentional acts or omissions or gross negligent acts, which those things can't be disclaimed by law anyway, by contract anyway. In no event shall either party hereto be liable for any damages, including but not limited to indirect, incidental, special, or consequential, etc. That's a weird thing to put in there. No damages, even though there's money being involved. Like, so that means you could just terminate the agreement and there's no damage? Like, what? As a lawyer, I'd have to really rethink this one. If I was writing this, would I want to have a clause that says there's no damages? We make this contract, but if you violate it, there's no damages. Is that really the way we make contracts? That's just... So that's weird. There could be a comeback to that one on Crytek's side, but, I mean, I'm looking at it in black and white. It's right here. It's weird. Termination. Each party shall have the right to terminate this agreement prior to the end, immediately upon written notice, if at any time the other party is in material breach, or the other party becomes insolvent, or admits in writing its insolvency, or makes attempts to assign for the benefit of creditors, like avoiding bankruptcy, files for bankruptcy, petitions for reorganization. Okay, so there's not a explicit right to terminate the agreement for any reason. But if there's no damages for terminating the agreement for any reason, then what are the damages? So that's weird. Yeah, some other attorney that's watching this stream, tell me that I'm not nuts here, right? They just disclaimed damages in a $1.8 million contract, or million euro contract. This is just kind of blowing my mind here, right? There's a damage disclaimer in a 1.8 million euro contract. What? So, I don't even know. I don't even really know. So this continues for some time now. And then here's the press release. And yeah, so they're going to switch over to Amazon Lumberyard. Okay, we get it. So that kind of speaks for itself. I don't have a lot more to say other than I concur. Of course, Crytek has 14 days, I believe it is. It might be a little bit different district to district. Some judges can make their own rules a little bit faster or longer. But Crytek will have approximately 14 days, I believe, to respond to this motion to dismiss. And then we'll hear a memorandum in opposition to the motion to dismiss, and they'll give all their reasons why they believe that it shouldn't be dismissed. Or they might try a second amended complaint, but they might have to get the court's permission for that. So either way, they will be hearing some kind of reasoning from Crytek next. Or maybe Crytek will realize that they're up Schitt's Creek without a paddle, and maybe they should just phone this one in and get someone to take them out of the game. But we'll see. Yeah, Crytek seems to have overstepped themselves. Why they would intentionally misinterpret that exclusivity clause, I'm not sure. So I'm curious to hear what their interpretation is and how. But other than that, I don't actually know all of the details underlying this, and I don't think most of us do either. I think we only have what we're able to see now that we see the game license agreement and such, and it does look compelling to me. It looks compelling. It looks pretty good for CIG and for RSI. That said, what are the consequences if Crytek loses or withdraws the case or something? CIG could ask for their attorney's fees and costs, maybe, but Crytek might have some opposition to that and might cite the same no damages under the contract agreement. So who knows if that, I don't know if that applies, because they're the ones that alleged breach of contract incorrectly, it seems. So what could change my interpretation? If Crytek comes back and has some piece of evidence that CIG and RSI are now hiding from the court and aren't revealing here, why would they have that and not have revealed it in their first amended complaint or initial complaint? So I don't think so. I really don't think so. Just in case there's any remaining question about this here, let me pull up the GLA. It literally does say, Crytek desires to grant the license to use CryEngine for the game currently entitled Space Citizen and its space fighter game, Squadron 42. So aside from the ridiculousness of how do you get the name of the game wrong in your agreement, assuming that there isn't something to say about that, it says both games. So, sorry, it says both games. Then we're going to hear from Crytek, and Crytek will say that it does not cover the two games and how they interpret that and all that. But it looks like to me right there in the beginning it says. So we interpret this at its face value unless there's something else, and you're saying Section 1.6 and Exhibit 2. Okay, so Exhibit 2 does say Squadron 42 and Star Citizen. No, why would anyone think that it would null and void the GLA? That's a really, really harsh remedy. If you're given a choice between something that fits nicely and something that doesn't fit at all, why would you take the thing that doesn't fit at all? If you're given a choice between interpreting the contract that Star Citizen and this game license agreement cover the things that it literally said in the first opening paragraph of the licensing agreement that it covered, why would you skip that and then go on and say, well, we're going to skip what it says up here, and we're going to interpret the other clause all the way down there to say that since it didn't say Squadron 42 down there, that must negate actively up here. No, that's such a stretch. It's Occam's razor. It's a much easier, fewer connections of logic, fewer leaps of speculation to get to that it says Squadron 42 right here. It says it down there. It doesn't say anything about not being able to use this for Squadron 42 despite saying Squadron 42. So where's the negating language? Where's the language that specifically negates its related space fighter game? Crytek grants license to use Squadron 40, where's the negating language? It shows that there's that Squadron 42 is a feature, but that's not what I would consider a negation of a contract right. I mean, you got an argument. I'm not saying your argument isn't there. Your argument is that this somehow negates the prior language. Maybe that's your meritorious argument to bypass a motion to dismiss and have a trial on this issue. That might be it. But either way, then those other things still have to be true then. If Squadron 42 is a feature of Star Citizen, then that seems to me that it's still underneath the license agreement. And so if it's still underneath the license agreement, then why is Star Citizen or Squadron 42 a violation? So I'm still having trouble with how there's a remedy or something against, in favor of Crytek and against RSI, assuming that these things that Star Citizen, RSI, CIG have said are true, assuming they're true in their motion to dismiss. I'm not saying they couldn't be outright lies. It's just not something I generally find in court pleadings. Usually there are, like we saw here, there are sort of misrepresentations of facts, but not necessarily outright lies. So certainly possible. Certainly possible. Well, we'll see what the judge has to say. Maybe if the judge disagrees, the judge will explain their reason why, and we'll hear all about it. Either way, I'm still disappointed that I can't play Star Citizen. So that's my biggest complaint. I would like to have this thing that we were promised, but that's a conversation you guys can have between you. So thank you for joining me. I think I'll end the stream there. It's definitely been fun. I hope that I was able to answer some of your questions and go through some of this a little bit easier than trying to parse it out individually. So everybody have a great weekend. I am Leonard French, your favorite copyright attorney. I'm going to go warm myself up with Mr. Meeseeks here, and you guys have a good cold weekend, and hopefully we'll all warm up a little bit later this week. Anyway, have a good one, guys. Love you all. See you in my next video. Actually, see you tomorrow morning for the Sunday live show. We will probably not talk about Star Citizen. Tomorrow morning, 10 a.m. on Twitch Eastern Time. Thank you to all of my supporters. I actually just did the list. Thank you to John Steele, Gavin Bernard, The Godslain, Evie, Andy, and Kyle Mudrak. You're my $50 supporters in January. And thank you to all the $5 supporters that are scrolling on the LED panel behind me. We're doing some new things with the channel. I'll have kind of a state of the channel thing tomorrow and a whole bunch of stories. So join me tomorrow. It's going to be a fun show tomorrow to open the new year with. So love you all. Once again, I'm your favorite copyright attorney, and we'll see you tomorrow or in my next video. Have a good one.